Thank you. So I would like to ask one question from Professor Veres. You have mentioned that this law has been in force in these territories for more than 160 years. And I would like to ask how the interpretation of this law changed over the course of this time.
Yes, this law entered into force in 1865, and it ceased to be applied in 2011. So practically huge social changes, even a Soviet-type dictatorship was functional with this civil code. And of course, some texts were changed and interpretation changed as well. This is reflected in the court practice. So it's very hard to give because it's a long code and covers a lot of social realities. It's very hard to give very comprehensive overview, but we can state that, for example, there were a lot of changes on family law, which was at first integrated, but it was not really based on equality between man and woman. And this is one of line of changes. Also, there was a modernization in property, also modernization in legal persons, also a modernization in the capacity of persons. So, but in general, the text of the code remained with very little changes in force. Of course, during communism, this was a capitalist code. During communism, it was put aside, and much more important laws were applied, but was in force and applied even during the Soviet-type dictatorship. And in 2011 was replaced by a new civil code.
Was any influence Russian law in Serbia in 19th century?
That's an interesting question. There was some influence, but not much, and mostly in the beginning of the 19th century. So when we're talking about Karađorđe's Serbia, the state of the first uprising, there was some Russian influence regarding the state organization at the time. So the Serbian Pravitelstvujući Soviet ruling council was modeled on a simplified version of Russian organs. There were some suggestions by Russian representatives in Serbia on how to improve the government on the liberated territory and so on. But after that, that influence reduced. Generally, regarding the status of Serbia, the Serbian struggle for autonomy, the international treaties between the Russian Empire and the Ottoman Empire were very important, because starting from 1820, the Bucharest Treaty, we had the promise of autonomy that only was realized in 1830. But regarding internal matters, after that, we turned to the closer models in the neighborhood, so mostly Austrian law, some French, some from other German states, but mostly not Russian law.
I would like to ask Professor Nina Kršljanin, when you mention free press, what do you think, was press really free? Because in Constitution of 1888, there was a provision which said that if press offend the king, it will be forbidden. But how to interpret the offense? Because when it criticizes the king's behavior, king can say, oh, they offended me. Thank you.
Well, of course, every legal norm can be subject to widely different interpretations. But first, compared to the previous laws from the previous 2 decades, let's not even take the 40s, but take the 60s and 70s, there you had the situation where every copy of a newspaper had to be taken to the police at least an hour prior to the sale of that newspaper, and the police did not technically have the right to censorship in the sense of changing the contents of the paper, but they could ban it if they thought any type of crime was committed by the texts. And generally, in practice, it amounted to censorship because the owners of the newspapers and even the printers themselves, because they all could be criminally responsible, they brought the drafts to the police to double check so they could tell them, oh, put this away because we wouldn't let you sell that. In that sense, compared to that, where any type of politically touchy subject could lead to a ban of the newspaper and with repeated offenses to the complete shutdown of the paper, here we have what is relatively standard for the time. So late 19th century, most European states are still monarchies, and in all of them it's illegal to insult the king. So generally that was fairly free press for the period. So you just can't insult your own ruler, foreign rulers and their families, but we're speaking, as the idea was, of personal insults, not just saying, I think that the state is not correct in this reform and so on, and you can't incite the people to an armed revolt. That is it. Compared to the previous, that's very, very free press. Naturally, by today's standards, we could find issues, but it's been a century and a half since then. Since you said that there still were some parts of that code that weren't transplanted directly from French law, but that were based on earlier, presumably Byzantine or earlier local regulations, were any of those parts criticized? Because in Serbia we have a slightly strange situation that on the one hand the Serbian civil code is criticized on relying too much on the Austrian model. One of the early critics said it was just an abbreviated translation of the Austrian code, and that phrase stuck for a century and a half. People were just repeating it, even though it had other models as well. And on the other hand, some of the provisions that were based on customary law, which unfortunately included, say, the priority of male heirs before female ones, the status of married women, etc., were also criticized by the more progressive elements. So was there anything of the kind? Because the situation seems rather similar to me.
No, actually, the critique was against the transplanted text and not the text itself. For example, there were written a book about the mistakes in translation. Huge book which were arguing that such a term is not apt to give back the juridical reality. And actually, the elements which were taken from the old customary law are very few. Of course, we can use as an argument, for example, there were special rights of inheritance of the poor widow, which came from the customary law. But it's very few that are those elements. So the critique are not directed towards those elements. It was translation, it was the adaptation of the model, and what it was seen, the general force of the French codification, that it has a simple language which can be understood beyond the circle of lawyers. That was totally lost in the translation, because there was full with neologisms, full with artificially created words to give back the content of the French code. So for ordinary people, it was not really a text which was understandable for a French ordinary people. The French code for the Romanian ordinary people, that Romanian text was not intelligible. So I didn't saw any critique directed against the very few elements preserved from the old law.